Good evening, everybody. I'm Tim Ansenberger at Adams and Reese, and I'm one of the co-chairs of the Ethics and Professional Compensation Committee. And we wanted to go over some of the issues that we think might be coming up in 2023 and that also might be featured in some of our newsletter articles that are coming out, and also might be topics for discussion in some of our panels for spring meeting and winter leadership. And the first topic that we think might be on the horizon here for 2023 are issues concerning all the lateral movement that we saw among lawyers moving from law firm to law firm in 2022. It really was a boom year. 2021 was big, 2022 was big. Partner moves were up 40% more than the average between 2017 and 2022. And associate moves were up 61%. And that included bankruptcy professionals for sure. And it wasn't limited necessarily to the bigger markets like New York. It was nationwide, people were moving law firms. And now that we're seeing bankruptcy filings uptick and the market for lateral hiring kind of slow down, we're thinking there's going to be a lot of issues concerning conflicts and conflict screening that took place when new lawyers came aboard. And we recently saw a case where this came up in the Third Circuit in September. It was In Re Maxis Energy Corporation. And there it was a Chapter 11, and the debtor's liquidating trust sued the debtor's parents' companies for fraudulent conveyances, alter ego claims, and those sorts of causes of action. And then during the bankruptcy case, a partner at the debtor's law firm lateraled to the firm representing the liquidating trust. And that lawyer had been involved in the bankruptcy, the name was on pleadings, and had been representing the debtor and providing guidance. So the debtor moved to disqualify not only the lawyer who was no longer going to participate in the case, but also the lawyer's new law firm from representing the trust. Here, however, the bankruptcy court and the Third Circuit agreed that the lawyer and the law firm, after the lateral move, did all the right things under the rules of professional conduct. The rule at issue is ABA Model Rule 1.10A2. And under that rule, the firm screened for potential conflicts when they brought the new lawyer aboard. When they identified the conflict, they set up an ethical wall. That included ongoing certification that the lawyers and staff working on the working for the trust were not going to be in contact with the new lawyer and some of the staff that she brought along about what was going on. And they gave prompt notice to the debtor that they had brought the attorney aboard and notified them on everything they had done to comply with the ethical rules. So the law firm and the lawyer here, they did everything the right way, which is good to see from ethics cases, because normally these decisions are when somebody does something bad, but here was a great example of what to do when you when a potential conflict or an actual conflict arises after a lateral move. Another issue that we see coming down the road are going to be retention and professional compensation issues in the crypto bankruptcy cases. Everybody knows the crypto bankruptcy cases are all the rage right now. And they're relatively recent filings, but they're already starting to see their fair share of ethics retention issues. And we're sure compensation issues are going to come along down the line once there's some applications for compensation filed. And one of the issues that's going on right now, it's currently being litigated and there's a hearing Friday on it, is in the FTX bankruptcy case. The firm that's representing the debtor, FTX, has filed its retention application, and it's being objected to by the US trustee and some of FTX's customers. And the issue is that the firm had represented FTX before the bankruptcy filing for years. It was one of their main outside law firms. And two of the lawyers from the firm left and actually went in-house at FTX. One of them ended up becoming FTX's general counsel just 14 months before FTX filed for bankruptcy. The U.S. trustee's main objection is that there's not enough disclosure in the application as to what role the firm played in FTX before the bankruptcy was filed, because we all know that based on what the debtor has said in its first day declarations, FTX suffered severe management issues, lack of management really, and some potential fraud. And so are there going to be conflicts that arise with having this firm that represented FTX on non-bankruptcy issues before the filing also represent FTX in bankruptcy? Alternatively, the trustee also just asked that the court limit the debtor's or the firm's representation of the debtor, and that it won't be the one responsible for an internal investigation or audit of the debtor's past, and instead an independent examiner should be appointed for that specific role. And then we saw that a bipartisan letter by 4 U.S. senators was submitted directly to the judge. It wasn't filed in the case, that also raised all these same concerns and asked the bankruptcy judge to appoint the examiner, and raised all these issues that they saw with the debtor's firm. In the next day or two, Judge Dorsey, who's handling the case, filed the letter on the docket and then made comments about it at a hearing and said, it was an inappropriate ex parte communication. And he emphasized that my decisions are going to be made based on what's filed in the case, the evidence I hear, and not outside letters. So that the hearing on retention in that case is Friday. It's probably just going to be the first of many issues we're going to see involving compensation and retention in these crypto bankruptcy cases. Another issue that's also going to be a topic at our panel for the annual spring meeting is bifurcated fee agreements. We've seen lots of opinions on bifurcation over the past 2 years, and we think we're just going to keep seeing them as more courts rule on the issue, whether they agree with bifurcation in Chapter 7 cases, or they disagree, or whether they're going to enter their own local rules governing how that's supposed to be done. We saw the U.S. Trustee's Office issue its guidelines on bifurcation just in June. So these issues are also evolving, and it's kind of one of the larger topics that we hear about when we talk about professional compensation in consumer cases. And then the fourth issue that we identified was overpayments of U.S. trustees' fees. Last year, the Supreme Court ruled that the 2018 increase in Chapter 11 fees to the United States trustee was unconstitutional because it didn't apply the same way to the 2 states with bankruptcy administrators. But the court did not tell us what we're supposed to do about it now. So we've had 3 circuits confront the issue so far, and all 3 have ordered that the government is to refund the overpayments. The U.S. trustee is saying that's impractical, and as long as we comply going forward, that should cure the issue. But all 3 circuits to date have said that there must be a remedy, and the most practical remedy is to refund the fees. And so we've got 3 circuits that have issued decisions, and I'm sure we're going to see more decide, and maybe we'll get a circuit split this year in 2023. So that kind of wraps up some of the issues that we've been looking at. As far as the committee goes, we are always looking for folks to write articles for us. So if you've got an idea for an article, you can get in touch with our newsletter editor, Adam Herring. His contact information is on the committee page for the website. You can reach out to him for any ideas you have. If you want to write and you don't have an idea, we could give you some ideas. So you don't have to wait for an email, making an all call for articles. Anytime you want to write, just get in touch with Adam. And then we wanted to plug our panel for the annual spring meeting, which we've teamed up with the Consumer Committee, who's also presenting tonight. And the panel is going to be Danger Ahead, Avoiding and Addressing Ethical Landmines in Attorney Engagement and Compensation. And some of the subjects that I've talked about today will be up for discussion at that panel. And that wraps up what the Ethics and Professional Compensation Committee has in their outlook.